Morning.
I have to agree, mine's sitting on my desk.
Yeah. Okay, so this should be a fairly quick meeting this morning. This is, we only have one item on the agenda this morning in reference to the retention letter from Rotzel and Andrus, legal representation of Geauga County Judge Timothy Grindell and Geauga County Common Pleas Court Probate Juvenile Division. Dave, do you want to kind of just give a quick
If
history?
I can,
Yeah.
we've been through so much in the last week.
I think I'm comfortable saying I know how this flows. We should have a flow chart here.
We should have.
Can you explain it to me? Because
Yeah.
of all
Yeah.
the things that we've dealt with, this is probably one of the most complicated.
I was up to about 1 a.m. last night sitting there, making sure I was
It's like-
reading all this correctly.
Yeah.
And I
So-
read that same thing.
Yeah.
Yeah, I mean, this all started, I believe, when the juvenile probate court wanted to get outside counsel on a couple of juvenile cases. And Prosecutor Flays had a problem with that, so he came to the commissioners and applied for counsel to pursue, defense of that action.
Mm-hmm.
So then, a while later, the juvenile probate court came and submitted a request and a letter from Rotzel, which was his attorney he wanted to select, and it was a retention agreement.
Mm-hmm.
And the retention agreement, stated, that he wanted to started working in defense of the juvenile probate judge.
Mm-hmm.
And so this office, initially reading it, had two issues. One, we had been informed that there was no pending or no action actually having been taken by the prosecutor against the judge.
Right.
So then the question might be, does the judge need representation right now? So that was question number one.
Right.
Question number two was the hourly rate. In the original engagement letter, Mr. Stephen Funk, the attorney for Rotzel, mentioned that his typical billing rate was $395 an hour. He was willing to mark that down to $365 an hour with a lower rate for an associate. So we consulted, this office consulted with the counsel that we had secured to help us with outside issues where there was a conflict.
Right. Because we had to go outside counsel.
Right,
Because
so
our
we're using
prosecutor-
Walter Haverfield, and the lead attorney's name is Todd Hunt. And he looked at it initially based on what we knew, and he said, yes, I don't see why it's necessary for the judge to have counsel right now, because it doesn't appear that the prosecutors filed anything against the judge.
Mhm.
And the law states clearly that the commissioner's office, their involvement in this process, well, first of all, it's supposed to be when outside counsel is requested, there's supposed to be a joint application that involves the commissioners. And part of the reason that's supposed to be the case is the commissioners, as the funding authority for the county, are supposed to have some say in how much is being paid for outside sources.
And we have to make sure that we have the budget so
Make sure we have the
necessary
budget.
and so on and so. We can't spend money we don't have.
So several weeks ago on a financial, we had some discussion. We approved encumbrances to get money set up in a purchase order for these outside attorneys. The judge had actually engaged another attorney to work on the issue in the Supreme Court that had been filed by Prosecutor Flays,
Right.
and also Rotzel and Andrus. So we didn't agree to paying any specific rate. We just simply said, we're going to put money in place that if something's agreed to, we're covered for any invoices that start coming.
Right. Right.
Okay. So ultimately, the board decided last Tuesday, so only a couple days ago, to send a letter back to Mr. Funk and Rotzel and kind of answer him back to say we are very respectful of the process of the right of the judge to seek counsel if he needs it. We just would comment that we don't think there's an imminent need for counsel, and we have some concern about the rate because the going rate for attorneys providing services to local subdivisions ranges down to as low as $175 an hour was quoted for an attorney that actually had been secured by the prosecutor.
Mm-hmm.
So we got I got a call the next day from Mr. Funk, and we ended up having a very nice conversation, and he explained issues that were involved. And one of the issues that were involved is that because the prosecutor had filed with the Court of Appeals challenging Judge Burt's order of appointment of outside counsel for the juvenile cases, that, their contention was, well, then that's something that does impact the judge. So under law, as far as the guidelines for appointed counsel, the argument there is, no, even though it's not right against the judge, it's against an order that was put in by Judge Burt that is in the interest of the judge. Therefore, Mr. Funk was advocating that, in fact, his client did need representation. And as to the rate, he came back and said, well, I had originally quoted $365, but I will extend to Geauga County the same rate that we charge the city of Cleveland, so that rate will now be $275 an hour, $90 an hour less, and for the associate, it'll be $225 an hour. So he then followed that up with the letter that's before you today, retention letter for you today to consider signing.
And I think one other thing that was in midstream in this process was also that the juvenile probate judge had filed a clarification of
Yes.
order appointing counsel.
Yes.
Basically
Correct.
seeking a court order or a contempt order
Yes,
against
and
the commissioners.
he sent that, he filed that late Tuesday afternoon after you guys signed the letter in response back to Rotzel. We were never copied on that. We were
Yeah.
just made aware that he had done that.
That's right. And-
So based on that, then we crafted a letter that I signed after consulting with each of you at separate times and consulting outside counsel back to Judge Burton, just saying, this is where we're at, this is
Right.
what we've done.
Right.
Because there were some things in the order that, we're reflecting perhaps the juvenile court and this office weren't on the same page with understanding certain things.
Right. I mean, in no way were the county commissioners, as listed in this this clarification order, seeking to deny counsel or anything like
Yes.
that.
Yes.
But the commissioners do have a right by law to negotiate the price, and that was all that we were saying is that we're a part of this process.
Right.
And then Judge Burt found that there was no contempt also, right? Correct?
Yeah, well, he didn't even bring it up. And
Right.
and if I can just quote part of his order that he issued yesterday afternoon in response to Judge Wendell's filing. It said, at the onset, it must be known the 11th District Court of Appeals has previously stated, quote, the sole role of a court of common pleas in the appointment process is to authorize the Board of County Commissioners to employ special counsel. Once such authorization has been granted, it is the duty of the Board of County Commissioners to provide for the compensation of that counsel. Given the specific language in RC 305.17, RC 305.14A simply cannot be interpreted to grant a court of common pleas any authority to set the amount of compensation for special counsel.
Right.
And he cites the Simmons versus Geauga County case back from 1997.
And then he does say also the court does not have the authority to set the amount of compensation for Mr. Funk or his firm.
Right.
Since the Board of County Commissioners and Attorney Funk appear to recognize that the board has the authority to determine the compensation of appointed counsel and the rate of compensation has been negotiated, the issue of the rate compensation may well be moot.
Yeah. So it's, to kind of summarize, it's the duty of this office to look out for the taxpayers. And, the court has the authority to order that counsel be provided for an elected official who needs it. But this office's job is to look out for the taxpayers and to negotiate a rate that, is looking out for those interests, but while at the same time ensuring that the elected official or judge gets the representation they're entitled to.
Right, and I think it's significant because Judge Burt recognized the statutory role of our office,
That's right.
Yes.
which
That's
is
right.
not only to help negotiate the rate, because we're the budgetary authority or the financial authority, but also to be involved in the process. And for
Yes.
some reason, people want to kind of avoid our
Separation of
office.
powers.
And
Yes.
so, but
Yeah.
us, even to the point where we can help select an attorney. Now, in this case, we're not going there. But we have a right to be involved in that process,
Absolutely.
to talk about what attorney we're going to use, what rate is going to be involved.
Absolutely.
And Judge Burt commented on that, and thank you to him for doing that. Now, all that said, we can't, this is my personal perspective on this, it's not our role to intervene. We're not attorneys.
Right.
We can't determine the merit of one side or another. We can't say whether the prosecutor is right, we can't say whether the judge is right. We don't have the legal training, the legal background, or the place to do that. And so it's really, as much as I hate it, because this is costing the taxpayers
That's right.
a ton of money, we don't have a right to intervene in that process. Our only role in this process is to ensure it's done as cost effectively as we can, and that it's reasonable and necessary, and that's the extent of what we can do. As I read the law and as I understand it, with my limited background, I didn't stay at a Holiday Inn last night, but
We've all had to learn a lot more about the law
But,
than
I mean,
any of us
that's
ever
right.
wanted to.
This has been a,
So,
as Tim
so,
said, I was up late last night trying
Yeah.
to figure this whole thing
so,
out.
so the advice I have received from our legal counsel over the allegations that the commissioners are denying legal counsel to authorize retention, to this retention letter is just simply not true. But I guess moving forward, the, to us signing this letter is in no way endorsing or agreeing with the actions being taken.
Either party.
Yeah,
Right.
We're not
either
taking a
party.
side
Yeah.
on this, we're simply,
Right.
saying, okay, we'll fund both sides and let the courts figure it out.
Right.
And so, that's our role.
But this also, in this order, does not mean that the juvenile court, or the prosecutor's office for that matter, has a blank check either. These dollars are gonna be specific to these two cases, not for any further
Right.
litigation down the road. They need to be specific, and it is very clear that this is not going to be a blank check. That's it.
Well, and actually, we didn't go there, and I don't know if we even want to talk about that. We have the right to set a cap.
Yeah.
And
So
So-
if we can negotiate a cap.
Right.
I mean, that's part of the negotiation process. In this case, there isn't a cap in there. But
And I don't know that it's necessary, I'm just putting it out there, and you and I talked about this, Dave, because of some other precedent stuff, and some comments that Judge Bird had made, that we have the right to be involved to that extent.
Right.
Because that's the past cases, stare decisis. And so, anyway.
And I guess just one side note to all this is, as this was all materializing yesterday, I mean, we were, it was like we were living it live.
Yes.
Yesterday. We did get a notice from the 11th District Court of Appeals that had essentially weighed in the favor of the prosecutor's office in putting the prosecutor back on both of these cases.
what started this whole thing.
Yeah. So, not that I don't think it settled the matter, because
No.
they could review this at a later date, but just to get a speedy trial for these two cases, they've gone ahead and put the state, or the prosecutor back on to represent the state. Yeah. And so, it's just been one big circle spending, I would imagine, thousands of dollars. We've got 3 law firms involved now.
Yep.
Not to mention the time and effort this office has had to put into that. I mean,
It's
this.
pretty much been a good part of my week.
Yeah.
And I was planning on
Yeah.
doing other things.
Yep, and I'm sure the other offices as well,
Yep.
in the courts times, and so.
Well, and to that point, I mean, I don't know if it will be clear unless stated, this was not a decision that this office could make. This was brought to us.
Right.
And we just had to deal with it.
But I think that what I was trying to get to, the moral of the story is to try to nip this stuff in the bud before it gets off the ground. And I think a lot of this probably could have been solved with a simple phone call,
Exactly.
right?
Exactly.
And I would also say, I bet you if this was your own personal money coming out of your check, you wouldn't be so cavalier to go
You
ramp
make
up
the call
attorneys.
before you start.
That's right. So
Start the
I
meter
know
running with a lawyer.
in my business and in my personal life, lawyers, attorneys, that is the final straw. That's because I've exhausted every resource in trying to compromise some type of negotiation or deal before I have to go down that route.
The
so.
historical context for Geauga County back to the late 90s, and Judge Bird referenced that case with Simmons, that apparently cost the taxpayers in excess of $1.2 million.
In legal fees.
And I think the elected officials in the aftermath of that were very cognizant of that, and there was a conscious effort for a number of years, certainly when I first started in this role in '05, where there was a stated commitment, we are not spending money on lawyers. But I think over time, that institutional knowledge fades and new elected officials come in that may have not been directly affected by that, but we went many, many years without spending a dime on lawyers and this kind of thing.
Yeah.
And now we're into a season where it appears to be standing up, and people are standing on principle, and it may be justified. It's just, I find it very, very unfortunate. 'Cause
Yeah.
this is money that cannot be used for other things that might be more productive.
That's right.
And helpful to the taxpayers.
So with that being said, unless you have anything else to add to this, Skip, I believe it's under the advice of our legal counsel to go ahead and approve this retention letter and sign that. But I just want to make it very clear where I'm coming from, that this is related to these cases and these cases alone. No further investigative litigation. This is not going to be and I think that the law firm that's representing both of them have an ethical obligation to make sure that we're not running up the tabs on these things also.
Yeah, and I'm not sure how we, how that's managed in terms of the engagement of the attorney going into, I don't recall reading in the letter, does it restrict the attorneys to this specific situation?
Yeah.
Or-
Yeah.
Yeah,
Does it?
I mean, the order
I
from
just didn't recall
from
that.
Judge Byrd is, he in his order, if I'm reading this correctly, he's basically said, beyond these two cases, this court's order of April 3rd, 2018 was not directed to any other existing or proposed litigation or legal services.
Good, good,
Yeah.
good. All right, well, then with that said, I'll
Yeah.
move to approve the letter.
Okay, I'll second that.
And you get to sign it.
Yeah. So-
Aye.
Commissioner Lennon?
Yes.
I'm going to recommend to the board, we're upcoming the budgetary season.
Yep.
And I'm going to recommend to the board that for the 2019 budget, we provide a little more detail. Right now, we have a line item called legal fees. I'm going to propose that we have some specific categories in there, so it'll be easier to go back and say, okay,
Yep.
whose actions did these legal fees originate with?
That's right.
So everybody can see, this is what we're spending, and this is where
That's
it
probably not a
started.
bad idea, some type of cost accounting there for sure would be helpful.
I mean, we can do it right now, but I think it's, just for transparency, it's good to, going forward, to be even more clear about, this is where we're
I
spending.
would also, it might be helpful for this board to understand what the going rate is out there. I know we get a pretty good deal, I think, with our relationships with, a few of the firms that do work for the county now. I think we're doing pretty good at, I think I've heard $175 an hour. That sounds like a bargain. But maybe more like if we had a spectrum there to be able to, just so in our mind, what's a good going rate for the town?
And I think the Lower Heffield guys give a pretty good deal.
Yeah.
And they treat us pretty nicely as far as the
Yeah.
rates and
Well, it's not only the rates, it's,
So-
it's how general are you when you're itemizing the bill.
That's
you
right.
know,
And
you'll-
the
you'll see
other-
on the some bills that it's like, I had this conversation, I'm not charging for that. which
Right.
is
so.
nice.
The other
some-
nice thing-
Some firms charge every 10 minutes, every 15 minutes, every 5 minutes. Some firms, and I know Walter Heffield does this, they'll take your call, they don't even log it.
Exactly.
And let's face it, we're a pretty good customer. We're a good pay. That's
Yeah.
one of the things they're looking for. It's
Yeah.
they could say $500 an hour, but are you going to get paid?
Yeah.
But we pay our bills. So
Yep.
okay. I don't know if anyone has any comments or questions or.
Go ahead, Dan.
Is there a number on Judge Byrd's decision? Is there a file number, case number?
On his,
For the
yes.
Can you provide that?
Yeah, so his, this would be the application of Geauga County Common Pleas Court Probate Juvenile Division for appointment of counsel, case number 18, miscellaneous 000318.
Okay, same one.
Yeah.
Okay, thank you.
So, other than that, go enjoy the rest of your Friday and weekend. Hopefully it warms up. Yeah. Yeah.
5 days of decent weather.
I think these two juvenile cases are in court this morning, so hopefully they'll both be.
The one was, I don't know about the second one.
Yeah. Twenty 21, right?
So today's the 20th.
20th, okay.
Okay.
Sure, I didn't take this. Yep, okay.
All right.
Thank you.
Good, Jim.
All right.
Thank you.
You're not going over?